One of the oldest subjects of discussion in legal philosophy concerns the relationship between law and morality. The separability thesis states that there's no necessary connection between law and morality. Legal philosophers disagree about whether the separability thesis is true or false. It's hard to even get your mind around the idea of a necessary connection between abstractions such as law and morality, but we'll try to make sense of this idea later. Before examining the separability thesis, however, we must examine the concept of morality itself. Many topics in legal philosophy can't be understood without some background in moral philosophy, also known as ethics. Unfortunately, the terminology might mislead you, so it's worth pausing to make sure we're all speaking the same language. People who aren't philosophers sometimes think of morality as a mysterious domain, the stuff of superstition, tradition, taboo, and religious dogma. They think especially of rules about human sexuality, lust, fornication, adultery, and such. This focus is too narrow. In philosophy, morality concerns matters of right and wrong in the broadest sense, with no special emphasis on sexuality. To give you an idea of the scope of morality, here are some simple statements that express moral judgments. She was wrong to shoplift that magazine. South African apartheid was unjust. You have no right to spank your children. It would be unethical of him to use a pseudonym on his resume. It's okay to have sex with an unconscious person. Genocide violates inalienable human rights. Now, I'm not asserting that any of these judgments is actually true. That's a whole other question. Of course, I think it's morally wrong to have sex with an unconscious person. That's sexual assault. These are just examples of statements with moral content. Some moral questions are, of course, difficult to answer, leading reasonable people to disagree. But there's broad agreement that actions of the following types are wrong, at least in some circumstances. Killing, maiming or injuring someone, causing them physical pain, inflicting emotional distress, physically detaining or confining someone, lying, deceiving, or defrauding, breaking your promises, stealing or damaging property, exploitation, partiality or bias, and in modern times, damaging the natural environment. Reasonable people today agree that actions in these categories can be morally wrong, at least under some conditions. There are also cases that command broad agreement. Reasonable people agree that injuring an innocent child for one's own amusement is wrong. The more interesting cases are ones that reasonable people disagree about. With this overview of what philosophers mean by morality, we can return to our main question. Are law and morality connected? The answer is surely affirmative if morality means moral beliefs and connected means causally connected. Throughout history, positive law has partly reflected the moral beliefs of lawmakers. Lawmakers use law in order to encourage moral behavior, to punish immorality, and to serve moral purposes in other ways. Most lawmakers believe that it's immoral to injure someone for no good reason. They create the crime of mayhem. Lawmakers in Iran think it's immoral for a married woman to speak to men other than her husband. They make that a crime in Iran. Lawmakers who believe that blackmail is immoral often make blackmail a crime. Law and morality overlap considerably in modern legal systems, but that overlap is only partial. Laws don't perfectly reflect anyone's moral beliefs. I think it's immoral to publicly mock a person with a physical disability, but such mockery is entirely legal in the United States. Laws may also influence our moral beliefs. Consider the case of sexual harassment in the workplace. In my lifetime, courts and legislatures in the USA gradually developed a civil cause of action for victims of sexual harassment. This legal development may have influenced opinions about the wrongness of such harassment. So law can influence our moral beliefs, and our moral beliefs can influence law. Law and morality are connected in these ways. But these are merely contingent connections. They vary from one legal system to another and from one time to another. The separability thesis doesn't deny that law and morality can be contingently connected. It merely denies that law and morality are necessarily connected. This is a philosophically controversial claim. Opponents of the separability thesis contend that morality is relevant to legal validity in all legal systems, regardless of what their rules of recognition say. This claim asserts a necessary connection between law and morality, thus contradicting the separability thesis. The claim is popular with the philosophers known today as natural lawyers. Natural lawyers support what's called natural law theory. Consider the traditional slogan, lex injusta non est lex, translated as an unjust law is no law at all. This slogan is associated with St. Thomas Aquinas, although his writings don't contain this exact phrase. Aquinas states that a positive law that contradicts natural law is no longer law, but a perversion of law. Such laws are merely acts of violence, according to Aquinas. The idea goes back at least to Cicero, a Roman orator of the 1st century BCE. The Lex Injusta slogan is suggested also in the works of the Algerian St. Augustine, and the great English jurist Sir William Blackstone. But the slogan has caused much confusion. John Austin misunderstood it as an empirical statement that unjust laws are never enforced. This is false, as Austin sarcastically observed. To other readers, Lex Injusta has seemed logically incoherent, both affirming and denying that an unjust law is a law. But there are other, less literal, more charitable ways of interpreting it. We can avoid the logical incoherence if we allow that the first occurrence of law has a different meaning from the second. Interpretations such as the following then become available. Every unjust norm is legally invalid. Every unjust law is defective as a law. One has weaker moral reasons to obey an unjust law than a just law, all else being equal. No one is morally obligated to obey unjust laws. Public officials are not morally obligated to enforce unjust laws. Public officials are morally forbidden to enforce unjust laws. One of your assigned readings is a paper by Mark Murphy, in which he suggests an interpretation of the claim that an unjust law is no law at all. Murphy understands unjust laws as unreasonable laws and suggests that such laws are defective as laws. They lack something that's intrinsic to the kind to which they belong. Murphy uses the analogy of a natural kind like an animal species, for example, the common duck. Murphy believes that ducks have a nature. There are certain characteristics that a duck ought to have because of the kind to which it belongs. A duck that lacks one of these characteristics is not just defective, it's defective as a duck. An ugly duck, he says, isn't defective as a duck, it's just aesthetically lacking. A duck that defecates in the park isn't defective as a duck either, although it may be disgusting and a nuisance to visitors. But a duck that can't fly or swim is defective as a duck. It lacks a characteristic that's intrinsic to its kind, a characteristic that it ought to have because of its nature. As you review Murphy's paper, think about how this analogy might apply to a social institution, such as law.